Good evening. Is mic on? Can you all hear me in the back? Yeah? It doesn't sound like it's on from here. It's on. All right. Well, good evening and welcome. It is fantastic to have such a full house. To all of our guests, we're glad to have you here. And of course, to all of our amazing students, you are the reason we're here. So welcome. And this is a wonderful tradition and a wonderful evening. I'm delighted to be here tonight for the 217 Len Edwards Lecture. As the premier, indeed the only public university in the Silicon Valley, I'm the president, so I have to say that every time I get in front of a podium, right? The only public university in the Silicon Valley. We welcome the opportunity to engage our students, staff, faculty, and community members in political discourse. And we here at San Jose State do it civilly. You're supposed to laugh at that one. No, that's a serious statement, I know. Tonight's lecture promises a lively discussion with a member of our state's judicial branch. This evening, we are carrying on the legacy of the man for whom this lecture series was named in 1995, Congressman Len Edwards. Just as our campus has a history of social justice, Len was a champion of civil liberties and civil rights. He was known as the Congressman from the Constitution for his unwavering support of these issues in his longtime service as a Bay Area politician. Through his initial endowment of the series, Len has made it possible for us to host an illustrious group of political officials and advocates through the years who have shaped our state and our nation. And I know he would be pleased with tonight's selected speaker, Chief Justice of the California Supreme Court, the Honorable Tani Cantil-Sakauye, who will be introduced shortly. Len would also be equally pleased that his own son, Judge Len Edwards, will be appearing with Chief Justice Cantil-Sakauye this evening. Before we move on, a sincere thank you to all the sponsors and supporters who have made it possible to keep this series running for more than a decade. Thank you especially to College of Social Sciences Dean Walt Jacobs. Walt, just wave your hand, say hello. Very important guy. And his staff, Christy Williams and Shannon Gallagher, who are here somewhere from the Department of Political Science, and Kate Lucio of the California Supreme Court for coordinating with us to have the Chief Justice join us this evening. Now, everyone, tonight is your chance to ask any burning questions you might have for our honored guest. Are you ready? Are you ready? Okay. Because this evening we will start with the Chief Justice engaging in a conversation with Judge Edwards, but partway through the lecture, political science professor Dr. James Brent will distribute index cards. He's right there. And you should ask for an index card, and you should write your question, and we will try to get through as many of the questions as we can. So I encourage you to take it away with those questions. Now, one small logistical announcement before we begin. In order to stay focused on the conversation at hand, may I ask each and every one of you, you know what's coming next, to silence your cell phones. Go ahead, do it. I'll wait. I'm seeing everybody looking down. Did I do it? And you know, somebody will forget and it will go off. So look again. All right. Thank you for that. And it is now my pleasure to introduce Santa Clara County Supervisor Cindy Chavez, who will in turn introduce this evening's speaker. Now, Supervisor Chavez is a true Spartan success story. And we have a number of very, very important Spartans here. And just sitting right in front of me, Senator Jim Bell, another amazing Spartan supporter of us in Sacramento. But Supervisor Chavez is a graduate of the Department of Political Science who is a current member of the Santa Clara County Board of Directors. She has also served on the San Jose City Council and as San Jose's vice mayor. Like the lecture series namesake, Len Edwards, she is an advocate for civil rights through her work as a labor activist. I am pleased to welcome Cindy back to our campus this evening. Join me in giving a warm welcome to Supervisor Cindy Chavez.
So, how many of you have met your president already? Have you met her before? Well, if you haven't, I'm so excited to have someone so enthusiastic about the Spartans and about our legacy and all the rest. Well, I am delighted and honored to be able to introduce two legends, really, tonight. I want to start briefly by talking about our Superior Court, former Superior Court, Mr. Len Edwards. Many of you will see in your booklet that Len Edwards has been and was a Superior Court judge for 26 years, and for 20 of that worked with the juvenile courts. But what he has in common with the Chief Justice is that they have used the rule of law carefully and thoughtfully to improve the lives of others. Judge Edwards did that by really changing the way we treat children in our criminal justice and our civil justice system here. And that's very important because that legacy has led to some of the greatest changes in the way we deal with children in our juvenile courts. We're far ahead of other places. We have much further to go because we want you to be proud of us. So, Judge Edwards, give him a round of applause. Now, our Chief Justice, Tani Cantil-Sakauye, is an amazing woman. She has a brilliant, brilliant legal mind and has been in the legal profession for so long. When I looked at her picture, I actually couldn't match that with the number of years she's been in office, and I'll just say you're welcome, Chief Justice. What is more critical to me about her leadership is that she has led the way to be thoughtful about the way we address our justice system in our state. She's advocated for more money, recognizing that the courts, frankly, right now, if you look at what's happening at a national level, are really, that rule of law is what's standing between authoritarian thinking and protecting the rights and the civil rights of everybody who lives in this country. But what is equally important is that she is looking at tough areas like bail reform, how we treat juveniles in our court system, how resources get spent across counties in a way that is fair, no matter if you live in an area that's wealthy or poor. So with that, I'm looking forward to hearing her presentation and then a discussion with Judge Edwards, and then I will encourage all of you to write your questions while they're speaking. So with that, I'm going to invite up our Chief Justice to address us. Give her a warm welcome.
Good evening. Thank you, Madam President. Thank you, Professor Brent. Thank you for inviting me to be here. Thank you, Supervisor Chavez, for that very kind invitation and introduction. It's an honor for me to be here for the Don Edwards Lecture, to be joined by my esteemed colleague and expert, Judge Len Edwards. I'm pleased to see presiding Judge Pat Lucas here from the Santa Clara Superior Court. Are there any other judges here? My colleagues from the bench? And if so, please stand. Okay, Pat, you have to stand for this. We might be the only ones standing. Thank you. It's my pleasure to be on campus, and I thank all of you students for being here, because I know if you're on the semester or the quarter system, you are studying and gearing up for finals. I know that from my own two daughters, one on the semester system, one on the quarter system. So that you're here, we hope to make it meaningful. Ask questions, please do. And thank you to your professors and your 8 colleges for making this experience helpful to you and for you being here. Because I'm the Chief Justice of California and I get 5 minutes with you before the questions start, it's always my pleasure to talk about what I consider the best branch, frankly, in government, and that's the judicial branch. And I can say that because I'm Chief Justice of California, but we are co-equal with the legislative and executive branch. And I'd like to explain the judicial branch in this way. This is the way I talk about it with people who are really new to our judicial system. And it's simple, but it fits. The judicial branch in California, like the federal branch, is like a 3-story house. The first floor of this house would be the superior courts, the trial courts, the courts you see on TV, the courts where you go as a witness or as a juror, the courts you go for traffic, the courts you go for all lawsuits. And on that first floor, In California, we have approximately 2,000 judicial officers who sit in the 58 counties, serving 39 million people. And California, like this room, is the most diverse state and the most diverse judiciary in the country. And since it's the United States, I'd likely say the world. And so, of course, if you lose on the first floor of the trial court, then you have the right, if you're either a felony or a certain civil case, you have the right to go to the second floor. And the second floor of the judicial branch is the Court of Appeal. The courts of appeal, there are 6 of them in California, and here you have the 4th District Court of Appeal, where all cases in the trial court at a certain level have a right to go for review. So if you lose at the first floor in California, you have a process, a due process to go to the second floor. And the second floor is the Court of Appeal, and that's where most law in California is made. And we have approximately 105 justices at the Courts of Appeal. Now we go to the third floor. If you lose at the Court of Appeal, you have an opportunity to petition or to ask to come to the third floor. The third floor of the Supreme Court, of the judicial branch, is the Supreme Court of California. And there we have 7 justices, myself included, of which I am chief. So in California, you go from 2,000 to 105 to 7. And if you were to think about if you had a case, your case would go from 1 judge to 3 justices to 7 justices. And I like to think of what we do and the work that we do as sort of like when you watch at the end of a movie, there's the credits that roll by. And there can be 10 minutes of credits. That's just like the judicial branch. The credits are the law, the legislators who passed it, like Senator Bill, the governor who signed it, and then all the lawyers who worked on it, and all the judges who worked on it, and all the witnesses, and all the experts, until you get to the Supreme Court and you render a final rule. And I tell you about the judicial branch in California because we are the largest judicial branch in the country. The Supreme Court oversees the largest bar, that is, collection of licensed attorneys in the country. So if you're in California, and you are covered by and entitled to come to the judicial branch, you are coming to the largest judiciary, the most diverse, the most law-trained judiciary, where we educate ourselves, we teach each other, like Judge Edwards, who teaches many of us on children and family issues, and we litigate and we clarify the rule of law that's passed on to us by the legislature to the governor's office. And what's significant about California is we also have what I call the white picket fence around the judicial branch 3-story house. And that white picket fence is called the Judicial Council. And that Judicial Council is in our California Constitution. It's an independent body. The Chief Justice, myself, is named chair per the Constitution, and I name the members. And the members do for the judicial branch and all the trial courts what they cannot do for themselves. So when you're in San Jose or Santa Clara, you have many resources and many talents, many judges. But when you're in a county like Inyo, where you have 2 judges or 10 judges or 1,200 people, that court cannot provide the same kinds of services to courts like Los Angeles and San Diego unless it has resources. So it comes to the Judicial Council for those resources. And why? And that's so that justice everywhere in California is equal. You shouldn't get less justice because you live in Trinity County, and Trinity County is in Northern California, and it has 2 judges and 1,000 people, but you'd get a different kind of justice in Los Angeles, which has 600 judges and 10 million people. Equal access to justice is our North Star. And in California, the judicial branch, through the work of the Judicial Council, ensures equal access to justice with the programs and the initiatives that we work on to better serve you when you walk through those courts. The judicial branch in California endeavors to teach ourselves. We have new judges orientation because you're a lawyer one day and you're a judge the next. How are you supposed to make that transition? No one else teaches it. So we at the Judicial Council teach that to lawyers who have become judges. They go to new judge orientation, and after 2 years, they go to Judges College. And presiding Judge Pat Lucas has been dean of our Judges College. And we have continuing judicial education because a judge who works in probate may one day have to go to criminal law and try murders. And how does that judge bridge that intellectual gap? By just like you, by going to class. And we offer those classes through the Judicial Council. And that's the work we do amongst ourselves. And we do it with the work of lawyers, and we do it with the work of court executive officers. We do it with the work of experts. We do it with work in the community, with lawyers and community-based organizations. And it's all for one endeavor. And that one endeavor is a public commitment to equal access for justice to you and your cause, and that we judges are educated, and that we judges are neutral, and we will give you a fair forum with laws applied equally to both sides. And in order to help us do this, to educate the public, we need to engage in civic education, because the judicial branch is the least known branch of the three branches of government. You can all name the leader of the executive branch. That's the governor. You can name, probably with a little research, the leaders of the legislature. On the Senate side, it's Kevin De Leon. On the Assembly side, it's Anthony Rendon. But when you're asked to name who the leader of the judicial branch is, you're absolutely stumped. It's me. Frankly, that's a weird thing that I sign every day, all the papers that say Chief Justice of California. But we found in studies, and recently as 2016, that 33% of Americans polled didn't think that the Supreme Court was part of the third branch of government. We also saw a poll that said college graduates, 10% of them thought that Judge Judy was on the United States Supreme Court. Now, we know at best she does small claims, at best. So we have a long way to go, and that's where our civic education comes into play. Because, as you know, in California, and especially today, change, important change that affects our lives comes about in three ways: negotiation, legislation, and litigation. And that means all three branches of government, and courts are a place of last resort. When you cannot get what you need in change through negotiation and legislation, you come to court to fight for it. And we guarantee you the equal access and the equal forum. And we need to explain that to all of you future leaders in California, that the road to change requires civic awareness, civic leadership, engagement, and critical thinking. That starts here. That's why you're here. And that's why I think the Edwards family and the lecture is to further expand how you think you will further that goal of civic engagement and change. And so I'm grateful to be here tonight to have a conversation with my friend Judge Edwards and to answer your questions as long as they're not about a pending case. Thank you.
So, Chief Justice, is this on? You know. It is on. You grew up in Northern California, and you went to public schools. In many ways, you are similar in your background to many of the students who are here tonight. Can you tell us a little bit about your childhood and why you became interested in the law?
Well, thank you, Judge Edwards. Yes, I can tell you that I came from a family where the highest education level when I was growing up was my mother's graduating high school and my father finishing second grade. And we knew no lawyer. We didn't know a professional. Our community was small, a Filipino community in Sacramento, so I only knew other Filipinos and didn't know of the greater world out there. And when I was growing up, we lost our home to redevelopment because government said we lived in blight. And I didn't know it at the time, but my mother went to court pro se without an attorney to fight eminent domain. And now knowing how complicated eminent domain is, I appreciate even more so what a courageous woman she was. She went to court and she lost. And more importantly, she came back from court feeling really humiliated and disrespected. And she talked about how the judge made her feel. And I was 9 years old, and I don't remember anything except this: the judge's name. I remembered him. I remember it now. And all I remember was the feeling my mother had. And also, I knew of strange things in my household, like my grandmother's name of her land couldn't be held in her name, so it was in someone else's name. And my Filipino uncle had to go out of state to marry his French wife. And so growing up, like many of you, I just absorbed strange things in the family. And then one day my mother took me to see at a forum like this the first and only Filipino lawyer the world in California had ever seen in my world. And no one knew what a Filipino lawyer was, but we all wanted to see what she looked like. And my mother said, you could do that. And I didn't know what it was, but I knew that my mother, who rarely had anything truly flattering to say, thought this woman was special. And so I grew up thinking about rights and unequal treatment and how to pursue that. And I ended up, through the encouragement of great professors and teachers, to pursue that.
That's a wonderful answer. Many of you know that Justice Sandra Day O'Connor graduated near the top of her class at a university just up the road here in Santa Clara County. And she couldn't get a job in the law except as a paralegal. And she was either number 2 or number 3 in the Stanford Law School graduating class. She was brilliant. And so she had to take a job that, not as a lawyer, nobody would hire her. Did you have a similar experience to that?
I did, in the sense that when I came out of law school in 1984, the job market was pretty thin, and so I came out without a job. And I had other jobs during law school because I had to pay the rent, and being an extern in a law firm didn't pay very much in Sacramento. So I dealt blackjack in Harrah's with my law school roommate, and so we would go up in the summer and we'd go up on the holidays and we'd make the cash and come home. And so when I graduated, my friends were still doing that because a lot of us just didn't have jobs. So I ended up getting a job as a probationary attorney in the Sacramento County District Attorney's Office, trying cases as a criminal prosecutor. And all of my electives up to that point in law school had been business. So I went in pretty cold, but learned through the good help and mentorship of others how to try a case.
Did you have the sense that there was gender discrimination? Did you encounter that as you were going through the struggle to get a legal position?
Thank you, Len. Yes, I would tell you that we didn't know what it was then. It wasn't really called that in the 80s. It was just, frankly, a dearth of females in law jobs. When I would enter a courtroom, everyone was male, and I was the only female. And I was called, honey and sweetness. And during trial, one judge in particular, I'd lodge an objection, and he'd say, "What's the matter now, honey?" And, I really think that he was just of a different generation, and he wasn't used to seeing women in the courtroom and at the table and arguing and fighting. And so, I didn't get angry. I just thought, if I put up with this, am I going to win my objection? Because, you pick your battles, and his intent was not negative, it was rather benign, and that was kind of the atmosphere. So when there was another female defense attorney, it was very common to go back to chambers to discuss the case prior to trial, and it was not uncommon to hear, "Well, what are you two little ladies arguing about now?" And so there was a lot of that, but at the same time, I want to say I never felt that it was ill-intentioned. It was more like, we don't know what to do with you because we've never really seen you.
I joined our Santa Clara Superior Court in 1980, and there was one female judge on the bench. And I think across the state, the percentage of women on the bench was very, very small. There's been a change, hasn't there?
Yes, there has. There's been a change. While I would say that males on the bench are still probably in the high 60% rate in California, we have more women than ever before, more along the lines of, I would say, probably 30% up. We still do not have much double digits of minorities or ethnic minorities in judicial positions. I think right now we have probably 11% Hispanic or Latino in the judicial branch. Asians and blacks have not yet reached double digits, but this governor, Governor Brown, is making huge strides in appointing quite a diverse and sort of the firsts of families and the firsts of generations and the firsts of folks to the judicial branch.
How diverse is the California Supreme Court?
There are 7 of us. We have a vacancy, so there's 6. And we are, let me start by saying how diverse we are. We do not have a white male on the California Supreme Court. That person is long gone, and we have majority female. Myself, Justice Corrigan. Well, we used to have a majority female when we had myself, Justice Werdegar, Justice Corrigan, and Justice Kruger. We now have my 3 females and 3 males, and we're awaiting a 7th appointment. We have probably a majority Asian, which is really unusual considering Asian numbers in the bar and Asian numbers of judges. We have myself, Justice Chin, and Justice Liu. But we have Justice Mariano Florentino Cuellar, and we have Justice Kruger, black female, also young, 2 children, 2 very young children. And we had our first baby shower at the Supreme Court 2 years ago. I'm sure that has never happened there before. So we are probably the most diverse bench, I think, in the United States.
History.
History, yeah, there you go.
What are the duties of the Chief Justice of the Supreme Court? You wear multiple hats, and I don't think anyone appreciates that. Why don't you give us a rundown of the different responsibilities you have, many from the Constitution?
Yes. Well, that's exactly right. So my official title is Chief Justice of California. That's sort of the umbrella name. And under that, I like to categorize my work by saying I kind of wear 3 baseball hats. So the first baseball hat is the hat I signed up for, which was to be one of equal on the California Supreme Court. So on the California Supreme Court, I'm the Chief Justice. So in addition to handling the same caseload as my colleagues, I also handle the budget and HR, and I handle the building issues, and I assign cases, and I sign all the paperwork, and I sign all the extensions, all the legal motions. I also take the lead in all of the things that the Supreme Court supervises. For example, we oversee the California State Bar, the largest collection of attorneys in the United States. And so I take the lead on overseeing that organization and a number of other organizations. So that's my hat as Chief Justice of California. Then I wear the hat that the Constitution tells me I have to wear, and that's the chair of the Judicial Council. That's the rulemaking and policy-making body of the judicial branch. So when you think of the 3rd branch of government as the judicial branch, and you think of us as co-equal, we're not just a group of courtrooms or a group of judges. We have a rulemaking body. I call them our board of directors for the branch. And the Constitution of California says that the chief chairs that board and the chief names the board members. And that's the board that does the teaching, and that's the board that does the policy and supports legislation and goes forth with initiatives for the branch as a whole. But then the 3rd hat I wear, which I've worn more frequently lately, is the Chief Justice of California, the hat where I represent the branch. And I'm kind of on the lookout for principles that threaten the branch. And that's where I will pursue initiatives on my own, particularly like civics engagement. I'm a firm believer in civics engagement, and I know my friend Les Francis is here, who joins me on our Power of Democracy committee to try to teach civics engagement, which we think is civic leadership. That's empowerment of young people to take our place and to be advocates, to be critical thinkers, to work with each other. And that's one of the pursuits that I am committed to as Chief Justice of California in that hat.
Well, you also are the chair of the Commission on Judicial Appointments.
I forgot that one, yes.
Okay, well, it's also in the Constitution, I think.
Yes, it is.
What do you do with that?
Yes, so the Commission on Judicial Appointments, which we affectionately call COJA, is a commission of 3. Myself as Chief Justice is the chair, and the Attorney General, Javier Becerra, or whoever the Attorney General is a member, and then the senior justice of the court affected. So we are tasked under the Constitution that whenever the governor of this state appoints a justice, that appointment is not valid until and unless COJA approves of that appointment. So, for example, in mid-December, there are 3 appointments to the courts of appeal that the governor made, all in Southern California. And so even though the governor named those people as justices of the courts of appeal, they cannot, under the Constitution, take office until COJA approves them. So we'll have a public hearing where people can come to speak for or against these candidates, and then the commission will vote on their qualifications as to whether or not they're able to assume the office of a Court of Appeal justice. And when the governor ultimately nominates a Supreme Court justice to fill the vacancy we have on our court, COJA will rev up for that hearing and again take testimony towards the qualifications of that nominee.
Why do you think that civil education is important in our democracy?
Well, how much time do you have? So I think, Len, that civic engagement is critical and civic learning is critical because the way to advocate change first requires that you understand what it is you're changing and you understand how best to effectuate that change. So it's important to understand government. It's important to understand local government or municipal government, state government, federal government. It's important to understand that the separation of powers means that each of the 3 branches of government have distinct jurisdiction and authority, and that civic engagement teaches you, a younger person, how best to be effective knowing this framework. And civic engagement also means not only teaching you about government and politics and history, but it also means becoming a critical thinker and analyzing a problem and finding a solution to it. For example, if you have a problem with a provision in the Bill of Rights, you're not going to go to Sacramento County to fight that. You know that you have to take that to federal court and go up the federal ladder, or Congress. So civic engagement teaches you about the world around you at whatever level you want to engage in it and to be most effective, not only to be a critical thinker and a problem solver, but critically, I think, to be collaborative, to work with people who are different from you, because you're not going to be king in this country. You're always going to have to work with others to effectuate change. You may have to litigate change. You have to kind of fight for change, and the way you do that is consensus building, collegiality, recognizing the value of argument, the strength of argument, and being a persuasive leader and effective leader. And civic engagement, teaching you about that world, is what will empower you to become that.
And that's why we go to San Jose State and become students, but also we'd like to think that everyone is going to be a lifelong learner, that civic education does not stop when you get a college degree. You want to continue your education throughout your life because you're going to be solving problems, and civic education helps you be a better problem solver. You mentioned you had 3 stories. How do you decide which cases go from the 2nd story to the 3rd story?
Thank you. Well, that shouldn't be the mystery that it is, but when a case, you take one case that travels from the trial court to the Court of Appeal as a matter of right. So when you get to trying to get to the 3rd floor, the Supreme Court, we have a very formal way of getting there. We call it a person has to petition for review, which is a very formal way of saying you have to ask permission from the Supreme Court to have your case heard. And the reason for that is primarily because of resources and settled law. So remember I said the 1st floor has 2,000 judicial officers and the 2nd floor has 105 and the 3rd floor has 7. And just in 2016, there were 6.5 million case filings in California alone. We couldn't hear with 7 people 6.5 million cases a year. So we use our resources, what we think is wisely, and we rely on the courts of appeal and their decisions to really shape the law. So the way you get to the Supreme Court on a case is really one of 3 ways. And the first way is that your case is creating such uncertainty and conflict in the law that the Supreme Court will take it in order to clarify the rule of law for the public, because the public relies on the stability of the rule of law, and we need to jump in and clarify it so businesses can make decisions, so people can make investments, so people can go to school. Those are the cases that we take to clarify. There's conflict amongst the courts of appeal on the second floor. The other case we'll take is a case of such statewide importance that it's roiling California. There's a time frame, and we have to act, and we know it's coming our way. So we might just jump in then and take the case so as to save resources, to get the final word, and to kind of just calm the waters. And the third kind of case, generally, that we take doesn't require a petition for review. They automatically come to the Supreme Court, and those are death penalty appeals, capital cases in the trial court, skip the second floor and jump to the third floor.
You have been interested in the issue of bail. Now, bail reform is something that Senator Bell is working on right now, and you'd think that bail reform would come from the legislative branch. But what can the court system, what can it do to have an impact on the bail system?
Thank you. I think that, I know this. I spent 14 years as a trial judge on the first floor. Like you, like Judge Lucas, we set bail every day. Bail was something that we just knew and did, and we did it almost pursuant to a statutory bail schedule. And over time, however, I wondered and questioned the efficacy of bail, and I believe we should reassess our issues and decide whether or not bail, that is money you put up to assure a court appearance and public safety, really does those things. Is it really meeting that? Does money make you safer? That's the question. And so I asked a group of judges to go study the issue. And I asked judges who were diverse, judges who came from urban counties and judges who came from rural counties, judges who came from conservative counties, and judges who came from more liberal counties. I asked judges who used to be cops. I asked judges who used to be public defenders to join this committee and research bail. And however you come out, let's see where we are. And this group got into a room, didn't agree on any single thing. But at the end of a year, unanimously agreed on 10 recommendations. And the first recommendation was, get rid of money bail because it doesn't work. Now, the other 9 recommendations bolster how we could make it work, make a risk assessment tool work. Because believe me, Washington, D.C. does not use money bail, and they've not used it for 10 years. And Washington, D.C. is still okay. Kentucky, New Jersey, Indiana, you do not use money bail, and they are still okay. So it's something California, I think, should look at with the good work of the legislature and input from the governor and input from the public about whether or not we should rethink whether bail penalizes poor people.
Thank you. You have taken a very strong position against federal interference and arrests in courthouses of illegal immigrants who are going to the court to do their business. I believe you wrote a letter to the Attorney General of the United States. What are your concerns about the arrests that take place in the court environment?
Thank you, Judge Edwards. So I was reading as of January about arrests that were happening in other states by ICE in courthouses. And I was gravely concerned because the principle of the separation of powers stirred in me the thought that judges and courtrooms, the judicial system, relies on the public trust and confidence of people who have a dispute to come into court, to testify against the bad guy, to report the bad guy, to be a juror, to take care of their traffic tickets, for all the reasons someone wants to put their life in order. And we in the courts, at least in California, we reach out to the community. We provide language access. We try to bring services to families. We even encourage people to bring your families to court. And we have children's waiting rooms for your children while you take care of your court business. We want the courthouse to be a safe place because the legislature passes laws that protect everyone in California. And we in the judicial branch believe in equal access to justice. But all of that is jeopardized if people fear coming to court. And they fear coming to court because they're going to be arrested by ICE. And this concerned me, and I waited as I read the paper for one of my colleagues in the other states, the chiefs, to speak out. And I read about it happening, and I didn't hear anyone speaking out about the principle. And so one day, after learning that there had been arrests in the Pasadena courthouse in Los Angeles, ICE arrests that had scared people away, I decided to do what everyone does to me. I wrote a letter to Mr. Sessions and Mr. Kelly. And I said to them in harsh words that they should not be stalking the courthouses and using the courthouses as bait because people come willingly to court. We encourage court. We want you to come to court. We provide self-help. But when they get here, they're shocked and surprised when they are arrested in court. And I knew under Obama there had been a policy where they didn't enforce ICE arrests in school districts, at hospitals, at funerals, because of the sensitivity surrounding those places. And I thought, of course the court should fall within that exception where you don't do ICE arrests unless it's a place of last resort. And so I asked to be on the sensitive areas list. And of course that was rebuked. And my whole point was, this is a separation of powers issue. We have 3 branches of government. I'm arguing that the policy of arresting in courthouses is bad for one of the branches. It's bad for the judicial branch. It undermines the public trust and confidence that we provide. It endangers the safety of communities. So knock it off. And it's turned into a national debate, and several chiefs have now spoken up, and we get reports back because courts are supposed to be for everyone. That's the law in California.
And I read recently that now Latinos in particular, or non-whites, have been afraid to come to court even if they are citizens,
Right.
because they are afraid they're going to be hassled.
Yes, yes.
And that is a cut against the access to justice principle that you have expressed and which is so important. We actually give an award out every year, don't we? The Access to Justice Award. And why do we do that?
We do that. We provide an award in the judicial branch because we are honoring people who devote themselves to the concept of equal access to justice. It's Thomas Jefferson who said, the laws are a dead letter if courts are not there to enforce them. This year, I'm told Governor Brown signed 6,000 new bills into law in October. All of those laws will one day, very soon I'm afraid, come to the courts because they are there to be interpreted to protect people. Sure, a law will pass, but its enforcement, its clarification happens when a court orders it to be. And that's what you do. That's what we all do. That is equal access to justice.
Who funds the courts?
Courts are funded in 2 ways, but primarily by the state general fund. Your tax dollars fund the court. But I should say, your tax penny funds the court. Because the courts get 1 penny and 1/4 of a penny for every dollar you pay. So we are the best bargain you can get because we serve 39 million people who speak 200 different languages, and we have no limit. We don't close, our doors are open for every filing. We don't have a limit, so one of those 6,000 laws will come our way on top of all the other laws. And we also get funding from fines and fees that the lawyers pay and have agreed to pay to keep the courts operating. But the judicial branch is part of government, and it enforces the law and clarifies the law that protects you. And I am a huge advocate for ensuring that justice gets paid for by government. I mean, it was Thomas Jefferson who said, "The first duty of society is justice."
Do we have enough judges now?
No, we do not. We are severely underjudged, particularly in courts that have experienced a population explosion, like the Inland Empire, Riverside County, San Bernardino County. I think San Bernardino County is the biggest contiguous county in the United States. Millions of people have moved into those areas, and they do not have enough judges to handle the cases that are filed based on that population explosion.
You have another job, don't you? And that is to talk to the governor and the leaders in Sacramento about the needs of the judiciary and the budgetary deficits that we are suffering. That's almost a full-time job in itself.
Yes, that is. It's a constant conversation about the use of where should revenues in California be placed. And my argument always is that all of the laws that are passed and all of the programs that are passed and supported, when they are challenged, they come to court. And justice must be timely and responsive. And in order for that to happen, courts must be funded properly. Our trial courts are the hardest working courts, I believe, in the United States, given our caseload. And they do good work. They do work that is reported on in other states. And they deserve the support because the money that comes into court comes to you in terms of services. Judges' salaries do not go up based on the government money that's given us for the judicial branch.
We have some audience questions, and I just have one more for you. A great majority of the Supreme Court decisions in the United States are 5-4 decisions, very tight, and one justice can change the result. How contentious and how divided is the California Supreme Court? Do you have a lot of 4-3 decisions?
We do not, actually. We have a very diverse bench, and we all come from, many of us from different governors and different backgrounds and different experiences. But for all of our differences, I think what it has done is it has enhanced our collegiality around the table. Our conversations are more robust and more free-flowing and broader as a result of the diverse voices on our Supreme Court. And I work with very smart and dedicated people who look to find a way to write a rule that's clear for people who are going to use it. And so we are primarily work hard toward unanimity. We work toward agreement because we understand that disagreement doesn't serve who we serve. That's not what we're there for.
I also noticed that I have some questions here. I also noticed that one of your justices makes suggestions to the legislature saying, here's a problem that we think you could fix.
Yes, in writing, reports to the legislature, we think you should step in, maybe you should take a look at this.
Yeah. Okay, first question from the audience is, what problems arise concerning the federal law prohibiting the use and sale of marijuana and the legalization of marijuana in California?
Well, since I can't specifically speak to any cases, and we don't have any pending before us, I don't believe, on marijuana, as you know, the federal Constitution is an independent document from the California Constitution. And though the two constitutions mirror each other in many ways and actually use the same words, those constitutions are differently interpreted. And so until the federal government really speaks definitively about what courts should do, we often rely on our California Constitution. But we already know that marijuana use and possession is illegal under federal law. And so California has a very difficult, I would say, tense relationship with the federal government. There will be that lawsuit that brings federal law and California law into conflict. Most likely, that case will be heard in federal court with federal jurisdiction over it. And maybe that will once and for all settle our tension. But states and independent state constitutions are independent living documents. And the truth is that a tension is kind of a good thing because it produces better law once the matter is resolved. A conflict sharpens your senses, gets to a better result, and maybe a more critical result. Maybe not as far-reaching as you'd like, but steps. So we'll have to wait and see for that case, but I think it's inevitably going to happen. It won't just be California. It could be Colorado that goes first. It could be Oregon that goes first. Those states already have more robust recreational marijuana laws that could therefore then be an issue for the federal government.
I don't think it'll arise in California. The other states seem to me to be ahead of us on that. You mentioned that people don't really know all that much about the courts, and these are the national polls. So where do you think the education needs to come that will let the public know and educate them about the nature of the courts? Should it start in grammar school, middle school?
I think so. I would tell you civic engagement, civic education should start K through 12, and it should really be about all three branches of government, and it should also be about courts and how they operate, and not just unpopular decisions by the court. And so, but the first responsibility with demystifying the courts and educating lies with us. It lies with the courts themselves. It lies with judges and justices. And to that end, I want to say that we at the Supreme Court have taken it upon ourselves to live webcast our oral arguments. So if you went to our Cal Courts website, you could find and look up old arguments. You could watch attorneys in action arguing before the California Supreme Court. Different courts of appeal also have now begun to broadcast their oral arguments and take their show on the road. They are now appearing in high school auditoriums, hearing oral argument. The Supreme Court goes to different law schools to provide oral argument. And trial courts do a great job of bringing students in and bringing legislators in and bringing the public in to see the courts and to know that these belong to you. And this is what we're doing, and it shouldn't be a mystery. We don't want it to be a mystery.
In 1997, you established and presided over the first court in Sacramento, dedicated solely to domestic violence issues. How did that come about?
Well, thank you for remembering. Yes, well, the Sacramento DA's office received a $1 million grant. And the public defender's office and probation wanted to start a domestic violence court. And I had just had a tragedy where my court reporter had lost her 2 children in a domestic violence incident. And so they came to me, the 2 offices, and asked me if I would start a domestic violence court. And I knew that it would be emotional and it would be difficult. But with the support of really good people who wanted to run the court and with the support of different counselors and different organizations, we put it together and ran and started a felony and misdemeanor domestic violence court. And it's still in existence today. And it does a world of good in Sacramento. And that was in the beginning. There were very few of those courts, but now domestic violence courts are prevalent in our judicial branch, and they really change lives. I am a firm believer that that court, I ran one for, I think, how many years? About 5 years I ran the domestic violence court, and every day I felt it was meaningful work.
The Judicial Council directed local cities and counties to stop requiring traffic tickets to be paid in order to appear. However, San Francisco County continues to ignore the directive. What can the council do to make it comply?
You should write a letter to me, and I will send it off to the right people to ensure that the law is being followed.
What was the hardest, most controversial case you ever had to decide? And I would give you freedom to choose trial or appellate court case.
Well, I would tell you that for me, the hardest cases, it's not one case, but the hardest group of cases are juvenile cases. And the hardest cases for me are the ones that I remember are when I was in trial court, and that is when juveniles are tried as adults. I look back on a number of serious gang and assault and gun kinds of cases involving juveniles who together don't make up an adult and have really juvenile judgment. And then adult laws and adult punishment is placed upon them. So when you have a juvenile, for example, who commits a really, and I want to, in all terms, a stupid crime that had no chance of success, and I could tell you stories about the idiocy of juveniles' judgment on cases and getting caught, and the seriousness of what they did, even though they didn't realize it. And when you come to a juvenile who's 16 and an offer is made for 17 years in prison, longer than they've been alive, they just can't even comprehend an offer like that. And so they end up going to trial and getting 15 years to life. It's just incredible. And I think about those young people who are in prison as a result of those laws in those days. And I'm grateful, frankly, that there's been changes that will give them an opportunity for youthful parole. Because, I mean, think of us. When we were all 16 or 17, the decisions we made, thank goodness we weren't held accountable to adult standards and adult punishment because it's long-lasting. Those are the cases that haunt me, the cases of seeing these primarily young men who might have been out on the street doing things they shouldn't have been doing, not hurting people for the most part, but scaring people, and very dangerous situations that could have gone off into different directions. And now they're in court, and now they're clean cut, and now they've been fed 3 meals, and now they're sleeping, and now they're in front of me, and they are in a clear mind, and they are really different from the people who committed those crimes on the street.
What did you major in college?
I majored in a major that I don't think exists anymore. I majored in rhetoric, which is, I think, communications now, I'm guessing.
Were you thinking about law school when you were in a major with rhetoric?
I was thinking about law school. I was thinking about law school when I was in community college. And the reason is I went to community college about for a year and a half, and I entered the speech and debate team, and I'd never done that. But I joined it, and I was in speech and debate against young men from universities, and they were very proud that they were going on to law school. And I was beating them in speech and debate, and I thought, well, maybe I should consider seriously going to law school.
You don't know this, but I've watched our Chief Justice speak probably 10 times, and I've never seen her with a note. She can stand and speak extemporaneously and brilliantly. It's something that I've rarely seen in anyone. That's not a question. How are you able to stay neutral while judging a case that may strongly challenge your personal values? Good question.
That's a good question, and I will say to you that, before we become judges, we're advocates for one side or the other. We are advocates, and that's what we do, and we come into court or to a hearing fiercely to push our points. But when you become a judge, that drops off. And you are to be a neutral. You are to be the forum and the judge that you always wanted when you were an advocate. Someone who can be fair and someone who can give both sides a fair opportunity and be respectful so that you can perform at your best as an advocate. Because no one wants a judge who is ready to pounce or who's angry or is thin-skinned. So judges are now in a place, after becoming an advocate, to find their footing as a neutral. And I'm not saying it's easy. I'm saying that you work at it. And over time, you learn to get better at it. And over time, you learn that if something truly does affect your ability to be fair, that is, you're not making your decisions based on the law but on your feelings, then we are required as judges to step away from the case, to recuse ourselves, we call it, to step away from the case and let someone else handle it. And that's critically important. And if we don't, there are repercussions later by the Commission on Judicial Performance based on our behavior. And it takes time. It's not as, all cases still have a gut feeling, but our focus for the most part is about making the right call on the law in terms of the objections or the instruction or the rule of law so that the parties can decide what to do with it. So it's not always easy, and sometimes you have to step away, and sometimes you find yourself looking and asking for a different kind of assignment because the nature of the cases you're hearing are such that are making you more difficult for you to be fair to both sides. And I'll give you an example. I was a trial judge for 14 years, and I had my children later in life. So I used to try a lot of molest cases. They were strong, important cases, good lawyers, bad facts. And I was fine with those cases. But once I had children, I found myself feeling a little queasier during those cases and feeling a little more uncomfortable. And so that's when I asked for I want a different assignment. I just think I would be better off in a different assignment. You want to trust the judge, but it takes time, and judges are trained, and they know as advocates, when they were advocates, they want someone who can put aside their feelings and hear the case.
When I was the presiding judge, a number of judges came to me and said, I'll do anything you want for it, but don't give me that assignment. I can't handle it emotionally. And that's wise on that judge's behalf, because the judge realized before he or she sat in that assignment that they really couldn't handle it. This question reads, I am deeply concerned with the role that the judicial system has taken in regard to the mental health system. How does the California Judicial Branch seek to change the role of the state and county jail away from being a holding place for the mentally ill?
That's a very good question. So as you know, the governor recently signed a bill this year that takes away the role of placement and puts it in the hands of the state hospitals. So that means placement of a person who may be found mentally incompetent to stand trial. So now that decision lies with the state hospital, and it lies with them to make a decision about where treatment should occur. Furthermore, in terms of mental health, let me back up a bit. A few years ago, one of our appellate presiding justices, Brad Hill, was in charge of a large commission to study mental health in California in our courts. We realized that the prisons have a large population of people needing mental health services. But you should know that the prisons are under the auspices of the executive branch, not the judicial branch. The judicial branch sentences inmates, but once they are sentenced, they become the jurisdiction of either the executive branch under the prisons or the executive branch under the county jails. And the courts lose jurisdiction and authority. It's only up until the time an inmate or a defendant or an accused is pending trial and in trial that courts have authority to order medication, to order treatment, to order housing. But once that changes and they're sentenced or released, the courts lose jurisdiction unless there is a special hearing having to do with the mental health of that particular individual. And so the courts are in a place now where I think great strides have been met with mental health courts. We have, for example, a mental health court in Sacramento County, which is much like mental health courts in other counties. And I decided that I wanted to spend a day in mental health court to see what it looks like now. And what it looks like now was, wow, truly and amazingly different from the days when I was on the trial bench. The judge in Sacramento County meets with all the mental health providers for all of the different people in court that day. And the judge hears from every provider of mental health services about the condition and status of that particular person who stands accused. And they talk about treatment, and they talk about well-being. And then the judge takes the bench and talks to that person about what they need and what's going on in their life. And then at the end, if the person has been complying with all their conditions of probation, the judge sends them on their way with two things: a cupcake, and a bus pass. And I have never seen that kind of treatment, and I advocate more of it. I advocate more of that connection of person to branch to community. But again, I tell you, those kinds of services are endangered if people are afraid to come to court.
We are very proud of the initiatives in the collaborative courts, and you've just described one, because we have Steve Manley in our jurisdiction here, who started the first Veterans Court, the first Mental Health Court, and continues to work with Sacramento on trying to get resources for these courts, which deal individually with clients, just as you've described, and that is the way to change lives. What advice would you give to a student looking to become a district attorney or, for that matter, a public defender?
Having been a deputy DA, I would say that work hard in school, read and write, and pay attention, become a critical thinker, graduate, take the LSAT, get into law school, and immerse yourself, if you can, in the work of not only your studies, but also when your schedule lets up, to do externships with the DA's office and the public defender's office. And if you get a chance and you have time in your, I think, schedule, which is harder to come by, join some of the bar associations. I mean, the Santa Clara Bar Association is such a strong, vibrant organization of attorneys. And find out and meet public defenders and deputy DAs. And find out if that's the work for you. But I will tell you that when you graduate from law school, apply to those offices. Now, sometimes those jobs are hard to get because you're in the courtroom and there's little turnover in those kinds of offices because it's exciting and endearing work, frankly. But keep at it. Keep applying and getting into court, even if you have to volunteer, even if you have to become maybe on the conflict panel or the indigent criminal defense panel. Get the experience of being in court. Because once you're there, or once you're on either side, it makes you more attractive to be hired by the district attorney's office or the public defender's office if you're not hired in the first instance out of school.
I think this is the last question. Everyone here at some time is going to get a letter in the mail which says that you've been summoned to be on a jury. Why is jury service important?
Well, I want to say as an aside, I have served on a jury 3 times. I was a lawyer, picked to serve on a jury. I was a trial judge, picked to serve on a jury and deliberated with the jury. And then as an appellate justice, I was picked on a jury, and I was there until the case resolved midway through trial. So I can tell you exactly why it's important. And that is, it's important because what if we told you could never serve on a jury? Serving on a jury is a civic engagement responsibility. It's a privilege. It's a privilege to hear evidence presented where the prosecution is attempting to prove that someone is guilty or the plaintiff is trying to prove some wrong has happened to him or her. It is probably the last bastion of direct civic engagement. Most of you will never go to the legislature to testify. Most of you will never go to the governor's office and meet to lobby a bill or a proposition. But all of you have an opportunity to go to court and to be a person who will be a neutral fact finder for a fellow citizen, for someone who's been charged with a crime or charged with a tort or civil liability. You get to be a judge. You get to decide the facts and discern truth from lies. And we rely on you for that. A jury of your peers. It's such a valuable, important contribution, and yet it takes a while. It's time consuming, but you want it to be. Because if you were accused, or you were accused of wrongdoing or a crime, wouldn't you want someone like yourself to be a critical thinker, to decide whether or not what they say about you is true? I can't imagine. Of course I would. And it's your opportunity to voice that. There can't be anything better.
Chief Justice, I want to thank you on behalf of everyone here for a very informative, enjoyable evening. And that ends our session tonight. Thank you all for being here.